thank you for the opportunity to speak on House Bill 441. My name is Aaron Minc. I'm an attorney and founder of Minc Law, an Ohio-based firm in Orange Village that helps hundreds of victims annually fight online defamation, harassment, extortion, sextortion, and other devastating digital privacy attacks. I've litigated hundreds of defamation cases across 25 states and served pro bono on the board of a regional newspaper in Northeast Ohio for over a decade. As both an Ohio business owner and practitioner who works in the trenches daily, I respectfully oppose House Bill 441. First, let me be clear. I understand and respect the concerns driving this legislation. I share prior proponent Mr. Kressig's concern for small businesses. I own one. I share broadcasters' needs for predictable legal frameworks. I depend on them to advise my clients. And I absolutely agree with the bill's proponents that frivolous defamation lawsuits over stale claims serve no one. However, HB 441 creates far more problems than it solves. It protects the worst kind of bad actors, those who plot and conceal malicious acts, while exposing responsible publishers to unclear and indefinite liability through its undefined each publication language that abandons Ohio's traditionally followed first publication rule. Passing HB 441 will make Ohio a national outlier, and it will undermine our otherwise excellent free speech protections. Last August, our Supreme Court addressed a real problem with Ohio's libel laws. What happens when someone hides a defamatory attack so the victim can't discover it right away? The court created a very narrow rule, applying only when publishers are secretive, concealed, or inherently unknowable to the victim. Think confidential personnel files, internal corporate memos, forged documents circulated behind victims' backs. The court recognized that letting wrongdoers run out the clock through concealment rewards misconduct and leaves victims with no recourse. Yet, rather than protecting Ohioans from these threats, HB 441 protects bad actors, including anonymous cyberstalkers using VPNs and fake accounts, competitors filing false credit reports, corporate actors bearing career-destroying statements and sealed files, and abusive ex-partners circulating fabricated accusations in private and on dating apps. We live in an era where AI creates deepfake videos, anonymous actors coordinate sophisticated campaigns, and false statements circulate in private forums, groups, and channels, causing real harm that victims often only discover months or years after the wrongful acts are committed and when the damage is already done. Ohio needs laws protecting Ohioans from bad actors, not laws protecting bad actors from accountability. Perhaps most concerning to me is that House Bill 441 provides zero remedy for Ohioans defamed by anonymous actors who cannot be identified within 1 year despite their best efforts. Ohio law currently provides no protection to stop the clock for concealed identification, no matter how diligently victims work to unmask their attacker. When victims discover anonymous defamation published either in secret or publicly and immediately file a John Doe lawsuit, they face an exhausting process to unmask. Subpoenas to Google, web hosts, internet service providers, and sometimes foreign companies. Each step requires court filings, often across multiple jurisdictions. Platforms routinely send objections that can take weeks or months to resolve. Critical IP evidence needed for identification is often deleted on short timelines, while defendants and platforms can contest disclosure at every stage with legal battles that can take many months to resolve. If a defamer happens to appeal a decision to reveal their identity, the appeal alone can take over a year to resolve. The statute of limitations keeps running the entire time. The defamer wins by default. This happens regularly in my practice. Small businesses targeted by coordinated fake review campaigns. Professionals attacked through anonymous posts on private online groups and forums. Victims of sextortion, revenge porn, and more. House Bill 441 tells every one of them that anonymous online predators can successfully run out the clock, and Ohio law will immunize their conduct and reward them for it. Beyond harming victims, House Bill 441 creates dangerous uncertainty for publishers. The bill states, quote, each publication, unquote, triggers a new one-year period for the statute of limitations, but it never defines what that means. For decades, Ohio courts have followed the first publication rule. One mass communication equals one publication, period. House Bill 441, on its face, abandons this publisher-friendly law without any explanation. This will increase defamation lawsuits against publishers and ordinary citizens alike, not reduce them. Ohio needs libel laws that protect victims, provide publishers with certainty, and prevent stale claims. This should include a narrow discovery rule, protection that pauses the clock while plaintiffs identify anonymous defendants, and an absolute deadline of repose to prevent stale claims like other civil torts, and clear standards for what each publication really means. Ohio already has extremely strong protections for free speech and against frivolous defamation lawsuits, including our new anti-SLAPP law that went into effect earlier this year. We need to build on these protections with laws that help businesses and citizens, not malicious actors. I respectfully urge this committee to reject House Bill 441 and work towards a solution that is balanced and protects victims, publishers, and Ohio's interests in both free speech and justice. Thank you, and I welcome your questions.